Santana.
Oh boy, we're being recorded. Better watch us.
Hello, everybody. Welcome today to our Lunch and Learn on the front lines of family and criminal justice, insights from the Honourable Justice Renee Cochard. Justice Renee Cochard is a supernumerary criminal judge of the Alberta Court of Justice, and she was appointed to the Edmonton Criminal Division in October 2015. And she is a Deputy Justice for the Northwest Territories and also has recently been appointed to the Law Commission of Canada. While on the bench overseeing criminal proceedings, Justice Cochard was instrumental in developing and opening Edmonton's Mental Health Court and the Edmonton Indigenous Court, and as a result was awarded the 2023 Indigenous Justice Award from the University of Alberta. Prior to her judicial appointment, Justice Cochard was a killer family law litigator in Alberta for 36 years. And over the years, she has taught a diversity of courses: family law, alternative dispute resolution, women law and social change, mental health in the law. And in 2025, she taught sentencing in criminal law at UVic Law. So we're here today to hear from the Honourable Justice Cochard. Hoping she will offer us some insight into lessons learned as a family law litigator and as a criminal judge. We have a few discussion questions along the way, but first I'm just going to open it up to you, Justice, to talk a little more about your past.
I'm very pleased to be here. You probably are wondering why somebody from Alberta, an Alberta judge, is talking to you in Nunavut. But I was asked by Michelle. I've been here in BC for some time. I live now in British Columbia, and Michelle and I were at one point partners because I was originally going to come out to British Columbia, leave Alberta about 10 years ago in 2015, and join Michelle and Christine Murray's firm. And then I did, and we have a lovely picture of all the five of us, and it's great in Victoria. And then about a month later, I got a call from the Alberta government saying, "Would you like to be a judge on the criminal court?" And I was actually, at the very beginning, I was really quite shocked about that, because I thought, why would somebody, i.e. government, want to nominate me as a judge who's practiced family law for 36 years? Why would you want me to become a criminal court judge? And they said, well, you'll learn. And it's true. It's true. I'll learn. But I think more importantly, I think that whoever appointed me, there was a justice minister at the time, had a pretty good idea that family law and criminal law actually go together quite well. And family law, I think, has made me a better judge, because I spent a lot, because in family law we want to hear stories, and we hear a lot of stories. And in criminal law, because of the approach, the adversarial system, stories tend to get lost, and we tend to hear more just the straight facts, as little as according to my criminal law practicing lawyers tell me, you need to know as little as possible. And I think I changed that, because I actually want to know more about people. And it's for that, one of the reasons I wanted to start the mental health court as well as the Indigenous court, because there I can look at context, and there I can listen to stories, and I can use some of my skills that I developed in family law. I also wanted to say that I think up north, most of you are, and I'm not sure if there's about 16 of you online. I don't know how many of you are actually living in the north, actually living or commuting or doing the commute. But I always practiced in a small firm. I articled in a larger type firm, realized that was not for me. And so I spent my whole career in a firm of, at the peak of 7 lawyers, all women. And we all did family law. That's all we did. So I've always been very supportive of people who've made that path, who've taken that path in the smaller firms. And I think up in the north, now that I've worked up in the territories, I see that a lot. The firms are quite a bit smaller. They're not the mega firms. So anyway, that's a little bit of history from my perspective. So what do we want to talk about?
All right. Well, we have a series of questions and hoping that you can talk through your insights about them and share any tips you might have for practicing lawyers. So our first one is, um, what about dealing with mental health and or substance abuse in family and criminal law cases? What tips or insight could you offer lawyers?
The issue in terms of particularly with mental health, and it's usually a combination, or at least when I was appointed to the bench, one of the things I saw right away is that you had the combination of mental health issues combined with uh, addiction issues. And underneath all of that was trauma. Primarily the people that I saw in my courtroom have suffered from some trauma. And it's not just a traumatic event, it's long-term trauma that occurred over the course of their lives. So it I think as lawyers, I think it's a really difficult area. One of my closest friends in Alberta is the legal aid duty counsel for the mental health court, and she has to deal with this on a regular basis. And she, you know, for her, and I think for me too, and sitting in the courtroom, the most important part was listening and being patient, because people with mental health issues and or addiction issues, they sometimes get a little they get a little angry sometimes, they get a little squirrely sometimes, they don't want to listen sometimes, they walk out of court sometimes, and it's just a question of not uh, being really patient with people. And sometimes I tell you, there are times when I wasn't that patient and I would lose it. But for lawyers, I think I really admire lawyers working in the area of crim and family law and working with people who have addictions issues and mental health issues. But I think the underlying thing, if you've got somebody with a mental health that you think has a mental health, dig into it, find out whether you're doing criminal or family law, find out some of the underlying issues. Find out what their history is, because I would always ask in court what's going on. But and sometimes, and I found as well that in practice I relied heavily on psychologists and social workers to assist me, because I'm not a psychologist and not a psychiatrist. So I relied very much on getting information from the therapist. And I would say to people, let's get you someone to talk to. And it's hard because a lot of people don't want to, I know myself, I don't really want to go to a therapist. So it's hard, but try to rely on people, get them into and ask them whether or not what information, or whether they have had any therapy. And you have to do it gently, right? I mean, I think you have to ask people. When I was in mental health court, it would always be, do you see a doctor, when people were getting a little bit or do you take any medication? Usually that's a good starting point. Do you take any medication? Because if they do, then you can say, well, what kind of medication? And as soon as they tell you what it is, and you have a pretty good idea that they must have some sort of doctor involved, and rely on those people because they know what they're doing. They're experts, most of them, you know. So family law is really hard. I think family law, I found that being a criminal court judge was not easier, but it was less stressful than being a family law lawyer. I think being a family law lawyer is really, really hard work. And I don't think that generally lawyers in, who do corporate commercial and that sort of thing. They don't give criminal lawyers and family law lawyers enough credit for what we do, because as a family law lawyer, we have to learn, and not just family law, but we have to learn about other aspects of law, bankruptcy, corporate commercial, all sorts of things, construction law, all this kind of thing, because those are the people that you're dealing with. And so I think it's hard work, and I think you need to be very careful for your own well-being.
Thank you, which brings us actually to the second point that we're going to talk about how to deal with challenges in particularly family law files, where currently in Nunavut, there are two different family laws. There's the territorial law that has come from the Northwest Territories and has not been updated yet, versus the new Divorce Act. So, which has better responses to family breakdown. So the laws are outdated. There's limited access to family justice, which means there's limited access to things like child support, spousal support, and property division, which can be tools to combat family violence and child poverty. So what tips might you have for managing a family law file with little resources and time in a place that there are few supports and limited lawyers and resources?
I was actually quite surprised when Michelle told me that the Family Law Act in Nunavut, it was based on the one in the Northwest Territories, and that's an old one and hasn't been revised. So I find that really surprising, because one would have thought that in 1999, when Nunavut was started, that they would have been working on and I'm sure they had so much to work on. So obviously it was easier to take something from the Northwest Territories. But I think that as lawyers, I think it's really important for you to work towards change. So there's the one part is handling the file, but the other part is sort of activism and working towards change and pushing the government of Nunavut, as well as the NWT, to change and modernize their Family Law Act to make it more accessible. And the government needs to talk to people in terms of what is it that the people want, as opposed to a top-down approach. In British Columbia, for instance, they've just finished a report by Dr. Kim Stanton, a lawyer, on domestic violence and responses by government to domestic violence. And one of the things that they did that I thought was absolutely just amazing, actually, was they had roundtables of women who had been within the criminal justice system on domestic violence issues, as well as in family law problems, who had suffered from domestic violence. And what they did is they had round tables across, and they said to these women, what is it that you think you need? And in Nunavut, that's something you could do, not easily, but in the communities, have round tables in terms of what kind of family law do you want? Because in the North, as in Quebec, many people are unmarried, for instance. And the question then becomes, how do you deal with property law with unmarried folks? Not all the provinces, Ontario, Quebec, for instance, don't give property rights to unmarried folks. So, yeah. How would that affect? And I think the Northwest Territories, the old legislation, the one you're currently under, doesn't give any rights to.
It does.
It does.
It does give
now.
Rights, yeah.
Okay, that's good. Okay.
Yeah.
But I think it's really. I think as lawyers, I think we have a responsibility to assist in change and to be active in making change. And I think judges in some ways do too, even though we're not supposed to be political, and we're not, but we're political and sometimes in the way we write judgments. So I think it's really important for those of you who are working in the North to challenge the laws that you currently stand that are unfair. We've got a low battery.
It's okay. We have 10%, and if you need to, we can turn around and put it in the plug-in.
So that's the first thing. And the second thing is what was the second thing? How do you manage with divorce? I don't know how you do that because I see that I work in Fort McMurray a lot, and in Alberta, there's the Family Law Act, which has been revised, but there are parts of the Family Law that don't jive with um, uh, the Divorce Act. So recently I did a mobility issue, and there's a lot of mobility issues in Fort McMurray because there are a lot of people who are working from Quebec, in particularly Quebec and Ontario, who Newfoundland, sorry, who are working in Newfoundland, or sorry, in Alberta, but want to move back if there's a separation or divorce, or the wife wants to move back. And one of the things I discovered when I was doing this family law trial a month or so ago, was that the Divorce Act has new legislation. It's great. I mean, it puts in a lot of what the case law had already said, but the Family Law Act in Alberta hadn't changed. So the question was, this was a family law matter as opposed to a divorce. I used the Divorce Act. And I think that's, you pretty well have to do it that way. I think you rely on the provisions, particularly when it comes to parenting, you rely on the provisions of the Divorce Act, even though it may not apply in your situation. But how do you get resources? I haven't got a clue. When I looked at the map of Nunavut, you see there's less than 40,000 people. You see that Iqaluit has what, 9,000 people, and the rest of the folks are scattered all over. How do you provide resources? Luckily we've got Zoom now. And that's a whole lot better, right? I think Zoom is, at least people can access therapy and medical information on Zoom. But I just don't know how you deal with family law, particularly domestic violence issues in smaller communities. I saw this in the NWT. I don't know what the answers are. What I do know is the criminal justice system doesn't necessarily work. That I know.
Yeah, I think that's an important point. And I think in Nunavut, it also, I think you made some good points about like the Divorce Act versus the territorial law, where the Divorce Act has the updated language, but the territorial law has the old win-lose language. And one of the things I'd heard last time I was talking with some people up there is that there's been a trend, like you said, to actually just use the Divorce Act language because it is better. However, it's not supported by the legislation.
That's right.
Yeah, so it's a tricky situation.
But the thing is you can argue it. The judge can make, and as judges, we make a decision. And if people don't like it, I guess they appeal, right? As my husband always says, just make a decision, Renee, and then they can appeal. Okay.
So many of the lawyers up in Nunavut, I think similar to Northwest Territories, do circuit court, go around to the communities and circuit court. I know you've sat as a judge in the Northwest Territories on circuit court. So, from your view, from the bench on circuit court, what kinds of tips and strategies do you think could be helpful for lawyers in that scenario that would help cases move forward?
One of the things that I really noticed when I was up in October of 24, I spent a week going various circuits. So a circuit in Sahuta, and I went to Delaney, Talita, Fort Good Hope, and Norman Wells. Those are the four we went, and it was a really interesting experience for me because and I'm sure all of you have had this experience where you all get on the plane with the judge and the clerk and the sheriff and everybody and the lawyers. It was really quite fun. We all stay at the same hotel. It's hard not to socialize. But one of the things that I noticed is Delaney, Talita, and Fort Good Hope all had about 600-700 people in the community. Two of those communities were supported by the Mackenzie by barges, and for the last 2 years, the Mackenzie River was too low to provide the barges couldn't come in, so everything had to be brought in by plane, or in the wintertime there's a frozen road, ice road. So there's very limited contact in those communities, and everybody knows everybody. And one of the things that I found frustrating in the communities was uh, within the system I was working with is you walk in, it's a community center. They set up a table. I'm sitting at the front. There's a place for the accused and his lawyer. There's a place for the Crown prosecutors, but there is very little interaction. So what we saw, or what I saw that week, was case after case, and there was a person who was a social worker who dealt with who worked for the Crown, but she was the witness person, so she would be contacting witnesses. So okay, time and time again, there were cases involving domestic conjugal violence, and they would be stayed. They would be dropped or withdrawn. And reason, because the witness, the victim, was not there. And the question then becomes is what kind of support, and you can understand why a woman might not want to appear in court in a community of 600 people, because we fly in and then we leave, right? We're gone. But you can understand she has to stay there. And how do you impose a protection order when there's only one store, the northern store, in the community? How do you impose a protection order where there's only one school and they have kids and they have to bring kids to school? You know, it 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 becomes really, really complicated. And it's so hard for these women to actually attend at court. And I get it. So what do we do? How do we do this? And one of the things I was thinking about, and we've really got to start taking a much more restorative justice approach in domestic violence. We've got to sit down. If I, as a judge, if the victim at least would come to court, if we could get her to court and she can tell me what she wants. Does she want this person to go to jail? In which case, okay, fine. That's fine. We'll deal with it by way of trial if we have a trial, or by way of a guilty plea. But if she's saying no, I don't want him to go to jail, but I want some changes. I want to be safe. Well, let's try to figure out how we're going to do that. And one of the ways that we can do it is through, and certainly I was told in the Northwest Territories, there was anger management counseling and domestic violence counseling, but of course by Zoom, right? And what I also noticed in each of the communities, and I'm sure that this is the same in Nunavut, each of the communities had a health clinic, fairly large health clinic with nurses there, and a social worker. So I think that would help. I also think that if, in my view, one of the things that I found with criminal lawyers, and I'm not being critical because I understand in terms of the need for, it's an adversarial system. I get it, beyond proof beyond a reasonable doubt. I know all of that. But one of the things I found with guilty pleas particularly, and what's important to me as a judge, when I get somebody and who's pleading guilty to, let's say, a sexual assault, not a violent sexual assault, but a sexual assault, or a physical assault, I look to the person and yes, I look at what their record is. I mean, obviously that's important, but I look at signs of rehabilitation. What has this person done from the time that they were charged until the time that they appear in front of me as as an accused person pleading guilty? What have they done? Have they done any treatment if alcohol or drugs are an issue? But more importantly, what have they done in terms of addressing the issue of violence and trauma? And have they entered into therapy programs? And, and I realize that counsel and sometimes has a difficulty where they've got a client who says, well, I didn't hit her, or We had a joint fight and we were both hitting each other. So I want to plead not guilty. I get that. But I think at that point, it's also important to say to the person, listen, we can run this. We can run it as a trial, or you may want to change your mind about a plea later. But in the meantime, let's talk about what you can do to make it look better in terms of better for you, but also better for the court. So that when I get counsel coming in and saying, my client has attended a treatment program of whatever, 90 days or 45 days, whatever the treatment program is. My client has done counseling for alcohol addiction or drugs. Mike or my client has done the program with regard to anger management and domestic violence. My client has taken a parenting course, which is always important to deal with some parenting issue. And my client is addressing issues of his or her own trauma. That is in some ways more important than the actual, let's say a person comes in and has a number of convictions. If they've addressed this, because I believe people can change and do change. And so if they may have a lengthy criminal record, but if they've started to address some of these issues, I'm much more I'm much more keen on looking at conditional sentences. And in the North, particularly, provided that there is safety, and I want to hear from the victim. So I think we can address some of these issues in terms of domestic violence in a more restorative approach, so that people come out of it healthier. And it doesn't work for everybody, but I actually think in most cases of domestic violence, people are remorseful. They do want to change, and they feel bad. I mean, I don't think that people want to go and beat each other up, personally. Not always, anyway.
Well, it's interesting. In Nunavut, there's emergency protection orders. Yeah. We all know what that is. But there's also CIOs, community intervention orders, and they are at this stage very, very rarely used under the Family Abuse Intervention Act. And community intervention orders are for situations where maybe there isn't an immediate emergency, but where both people actually want to come together to
that's a great
create
thing.
Change. So I think there's been a lot of talk about how can we in Nunavut increase the use of CIOs. And I think one of the things is right now they require a court order. And do you think that would be a hurdle to having those types of orders? What use do you think?
I think most of your judges, if you come to court and you ask for a community order, I think you get it. I don't think there'd be any issue. But the thing is that both parties obviously have to agree to that, right? I would think.
Yes.
Yeah. But I don't think there'd be any problem. And that actually sounds like a great program. We don't have that in Alberta, and I haven't seen it in the NWT. So I'm not, maybe they do, but I certainly haven't seen it. But that seems to be a really important, because we do have in the criminal code community impact provisions, like just like victim impact statements. You have community impact statements. I'm not sure how often they're used in Nunavut, but they seem to be used more in the north than they are, because what impact does it have on the community if someone has been violent towards a spouse or another person? So that's something to press for, actually.
Mm-hmm. Yeah,
and that order would include provisions to take treatment or to do some counseling, or
it can also bring in like elder counseling or other community members. So yes, I think figuring out a way to encourage the use of CIOs in appropriate cases.
See, I don't think you need, like in Edmonton, we needed an Indigenous court. But because we had an urban Indigenous population, a fairly large one. But in Nunavut, you already have the Indigenous people are there. The elders are there, right? And so you've already got all of the tools. And one of the things that I found in Indigenous court um, was we had our elder. We all sat around a table, but one of the things was the important part for me and for the people there. I think for the especially youth, it was the elder being there. I and that's one of the things in the Northwest Territories. I wish they would have had an elder in every one of those courtrooms. But the elder helped us so much, helped me understand things, and was willing. And it was really interesting watching young Indigenous, particularly men, um, respond to the elder and the women as well. Of course, they responded really well to their grandmothers too. I was just amazed, actually, how well they responded to their grandmothers. But I think you've got the tools there, right? You've got your elders there. The ceremonies are there. Everything is already there. You just have to bring it in. We need to bring it into the courtroom. And last week here at UVic, they opened up the Indigenous Law Center. And one of the things that they're doing, their first projects, is called Next Steps. And it is taking 5 Indigenous communities within British Columbia and working with them to bring in Indigenous laws into their community to deal with whatever issues are coming up. And it's a really interesting project, because I think we need to bring in Indigenous laws within the criminal justice system. We have to start working with them, because there's a lot of information there and help.
So one of the last things we were going to talk about before just seeing if there's any questions is, and you kind of already touched on this, about any sentencing tips for lawyers.
Okay, so getting as much information as possible. One of the things that I was writing down yesterday was sentencing. As I've said already, I want to know what efforts people have made since the charge. What have they done? What have they taken? What efforts have they done? And in particular, with regard to domestic violence counseling, parenting, as I've said, and treatment. If they're in custody, and have been in custody for a while, then the question becomes, what supports have they accessed in custody? And I realize that that's very, very difficult, because there are not a lot of supports in custody. But what's available to them, I want to know what's available to them if they are released into the community, and how do I protect if there is a victim, how do I protect the victim in the smaller community? I also want to know, and often I don't, and I'm not sure in Nunavut whether you use the Gladue report or whether you use a PSR report with Gladue factors. I personally like the Gladue report better, because the PSR is not as personal with the Gladue factors, but I know that financially it's sometimes not possible. In Alberta, it's all paid for by the government, the Gladue reports. I'm not sure about Nunavut, but often I'll ask a lawyer, well, has a Gladue report been prepared? Because I can look at a person's record and I see if they've got a long string of convictions. Well, hey, there probably is a Gladue report. So it may not have been done for this one, but it was done for something else. So check and see whether or not there's any reports done. In addition, if you're dealing with a young person, I tend to somebody that's an adult, but a younger person. I tend to ask if they have a youth record, whether or not there's been a Section 34 report done under the Youth Justice Act. I ask that because I think it's important. There sometimes is, quite often there is, and having been an assessment. I also ask whether or not there's been any mental health assessments done in terms of fitness in the past. I asked whether or not there's been any assessments done at schools. I'm trying to get as much information as possible because sometimes, for instance, let's say a 20-year-old, there's been an assessment done at school that they've been diagnosed with FAST. Okay, then we have to tailor this. I have to tailor the sentence to meet that. So I want a lot of information, and I know sometimes it's a pain in the butt, but I also want to know. I also want to know about I was reading a case called Kayak out of Nunavut, and one of the things I was interested in is the lack of information in that case. Now, it may be that just the judge didn't put it in, but one of the things that interests me is Clyde River. It was a domestic case. I don't know anything about it, Clyde River in terms of what supports are available in that. I'd like to know that if I was sitting up there. The other thing, in a decision of Kayak JM, paragraph 19 refers to previous decision on gendered violence, and I think that's fairly is actually a very important decision. The other thing I think I'd like to or I want to know is the time in custody. I am very aware as a judge that custody is difficult, very difficult, and particularly in remand. And I'm also aware that 70% of the people in this country who are in prisons are on remand. So for me, remand time is important. Most of it's dead time, as we call it. In Edmonton at the remand center, for instance, there's no access to family, limited. You can have some video conferencing, but your family has to go to the other end of town to contact you. It's very difficult. Little access to lawyers. Yes, they can go in and see them, but the remand center is quite a ways away. Programming is pretty well non-existent. There's some, and mental health resources within the remand center is low, and we know that federally it's the same. So I want to know in Nunavut, if you're not federally sentenced, then there's the remand center in Iqaluit, and I want to know what kind of conditions those are. So because everybody says, okay, it was 1.5 to 1, but the reality is I've often given more than 1.5 in situations where I think it's especially in COVID, but also in situations where people have been put in what they call protective custody, as opposed, it's really solitary, but protective custody. I want to know that information. Give me that information, because make a pitch. All the judge can say, well, I'm only going to give 1.5. Well, okay, but at least you've made the pitch, because sometimes you'll run into a judge who has similar thoughts to me, and give less. And then the other thing is if it's a federal sentence that is being pitched, let's say a joint submission, I need to know where this person is going to go, as to whether or not there's any recommendations you want me to make in terms of the kind of facility. There are healing lodges for Indigenous people across the country that were set up after the Ashley Smith matter, and they're underused. And the reason they're underused is because Indigenous people tend to have higher security classifications. And this is all, we know all of this from Dr. Zink, the correctional investigator. And so the healing lodges, although they're great, and we know they work, are not being used enough. So if you've got somebody who's going into federal prison, find out where the nearest one, because to me, going south, especially if language is an issue, it must be really, really hard, to be taken away from your community, to be taken away from your language, your family. They can't visit. So find out what the conditions are going to be in whatever federal institution. I mean, I know that people have to go to federal institutions. I get that, but find out. and let the judge know this is where they're going to go, judge. So if you're arguing for maybe a provincial sentence as opposed to a federal sentence, I need, if you think you might be able to get that, let the judge know what those issues are in federal prison.
Right.
I really recommend that you read or look at the reports, and you probably have, of Dr. Zinger, the correctional investigator, who unfortunately is leaving early because of the lack of mental health, the lack of work being done at the federal level in terms of mental health resources. And if you think it's bad at the federal level, just wait till you go to the provincial level. Lastly, I just want to mention something about trauma. Most of you probably know her, but Myrna McCallum is a lawyer in British Columbia, and she spent her career on trauma-informed lawyering, and she teaches judges trauma-informed judging, and also teaches about trauma-informed for vicarious trauma that we judges, lawyers that you see every day, and how to deal with that, because it's not just the client that is has been subject of trauma and our suffering. It's also us, and we forget about us. I'm pretty good at compartmentalizing my work from my life, but I still remember a 4-year-old, an inquiry that I did with a 4-year-old child who had died in care. And she was 4 and she was 20 pounds. And I remember the autopsy pictures. They still come back to me on a regular basis. This little 4-year-old, quite tall or quite long and just totally skinny. I still remember a inquiry I did of a death in custody at the remand center of a man who died of an overdose, supposedly who'd been on methadone, and there was no explanation as to how he managed to overdose. But I remember the correctional officer, looking in and seeing him there, but not doing anything, because the man on the bottom bunk was holding this man's hand. And obviously was giving him comfort, but while he was dying, I remember that and the officer just walking the other way. I remember a video of a murder where it was a convenience store murder, where at the very end they've got all their stuff, they're walking out, and the last guy in line, and there's this man crouched behind the counter, and the last man and shoots him in the head. That's, I remember those things, just like you remember if you've dealt with murder, domestic violence, sexual assault, child porn, for instance. And please don't ask the judge to look at the porn. There's case law on that. On child pornography, generally speaking, a description is good enough if there's a guilty plea. But look after yourselves. I think that's really important for the work that we do, all of us, actually. So it's not just our clients. And if we're healthier, it's better for our clients too.
I'm just going to turn us around so we can have it over here. So if you could come over here, Renee. So everyone. Okay. Here we go.
Also, lastly, I wanted to talk to you briefly about the Law Commission of Canada. I'm a part-time commissioner there. It was resurrected. It used to be called the Law Reform Commission, and over the year, it was shut down in 2006 and then resurrected in, I don't know, 21 or 23. Anyway, we've just sort of started again. But one of our projects is the prison law project, and I want to put a plug in for that, because my shtick as a commissioner has been, we need to know what's going on in terms of prisons in the North, particularly, and the effects on individuals, and so who are sent, as I've said, to the South or even the effects in terms of the type of facilities that are available. So at the moment, what we're doing is we've commissioned a series of papers, but I would really, really like it if any of you have any concerns about prison and the facilities up Nunavut, the concerns about moving people to the south, whether there should be a federal facility up north. Please contact me. You can contact me through Michelle, and I can bring this up to the commission people, the people doing the research. But I really want to get information as to how you, as lawyers, how you feel about the facilities available in the north. And so it's great. We're also doing a project on charity law, but if you look, which is sort of interesting, but it doesn't interest me as much as prison law.
Okay. Well, I'm just looking at time. We have 10 minutes. Santana, I don't know if there's any questions there.
I need to hear from you as to what you're thinking. I wanted to, when I graduated from law school in 78, but the year I started law school was in 1975, which was the year that Bev Brown, your first Chief Justice, was appointed, or sorry, finished law school. And then she was in my sort of circle. I was younger, a little younger, not much, but she was in my kind of circle of lawyers that I hung around with. And then I've always maintained contact with her while she was in Nunavut, and then later in Alberta. She was I don't know how many of you would have known Justice Brown, but she was an amazing person. And I know that her son, Andrew, is now a lawyer up there in Iqaluit, and her daughter is a teacher up there. When her mom moved back because of health reasons to Alberta, they stayed. And Andrew graduated from, I'm not sure if he's on the line, but he graduated from the Nunavut Law School. So that was kind of neat that his mom helped set up.
That's awesome. Okay. Well, I didn't see Santana join with any questions.
How can you see it?
I can see that her microphone's blocked, and I figured she would pop on and say something.
No questions.
No questions. Okay. So a few last minutes. Renee, I've heard you talk about this before at other talks. And I think even though there is not the same kind of court infrastructure in Nunavut as other places, there's a real access to justice issue there. But I've heard you talk a lot of times in the past about, as lawyers, using your lawyering for change and bringing cases that can make changes to the law. And I thought that might be just an interesting way to finish.
Yeah. When I graduated in 1978, that was the first Matrimonial Property Act in Alberta, which came in on that summer, actually, when I graduated, that summer of 78. And there was a whole lot of litigation at the time to determine what is property, for instance, pensions and stuff like that. And then when I started with family law at that time, we were lucky to get child support of $50 a month. We were lucky to get any spousal support. Marital rape was still allowed in this country. Obviously same-sex relationships were not recognized. All of those things have come about because lawyers, we worked hard and we took cases to court. I was never afraid of going to court. I spent most of my time there, but we had to push it, right? You had to go in and you had to argue for spousal support. I don't know how many times I was in court in spousal support, child support. And because of lawyers, a friend of mine took a case on child support and which resulted in a decision called Levesque, which said, and it was, of course, a female judge who said, child support is absolutely terrible in terms of the amount. She used to bring in bags of clothing and shoes and stuff and said, this is what it costs to raise a kid. This is what I just paid for my kids to go to start school. So as a result of Levesque, which came out with the formula, we then went to, that started the ball rolling for the federal child support guidelines. Because of a number of cases that as lawyers we brought on spousal support, the end result was Moog, and a lawyer in Manitoba. That's a little case, an absolutely little case, $100 a month spousal support. He took it all the way to the SCC, and we came out with Claire Leroux-Dubé wrote Moog. That was the change which led up. That was the case that led up to the spousal support guidelines. The same with records in sexual assault cases. It's because of the Mills decision. There are all these cases that lawyers we brought to court, and we said this law needs to be changed. And of course, in 1985, we got the equality provisions, and then the charter, obviously, in 1982, and lots and lots of cases are still coming to the forefront in terms of charter issues. I mean, you see this all the time in the Supreme Court in terms of mandatory minimums. And it's because lawyers bring these cases to court. The most recent one was Senville, and which got a lot of flack because it was a child porn case, but it challenged the mandatory minimums on child porn cases. So, as lawyers, I think we have a responsibility to keep up the fight. Maybe a lot of stuff has been dealt with, but there's still a whole lot of stuff that needs to be brought forward. I see that there's a case coming in front of the SCC that's challenging Jordan. And really, is Jordan really responsible? The question is whether or not Jordan's really responsible for stays that are being entered, or is it a lack of resources? And so we need to bring this up as lawyers and as judges as we write our decisions. We have and the other thing is working in the volunteer community. I spent a lot of my time with LEAF and the Canadian Mental Health Association, and again, trying to affect change on issues of equality as well as mental health issues. So I think, what I see, all of you younger lawyers, when I look at your resumes, I can't believe how much work you guys have done. Like I just, when I taught this year in sentencing, I saw all of your, I saw the resumes of the people coming into my class, and you floor me. I don't think I could do that. I don't know if I could get into law school anymore, because you guys are just so amazing. The younger lawyers, some of you on the line may be older like me, but the younger ones have done so much. So it's really gratifying as an older person to look at these resumes and to see the kind of work in the community and within the profession that you're doing. So I commend you for all of that. Keep up the fight.
All right. Well, thank you, Renee, or thank you, Justice Cochard. As always, I find it really inspirational to talk with you and listen to you. So thank you so much for doing that.
Well, thank you. I hope it's really, I wish I could see you. I can't see you. Do take care. These listen and learns are great. We do them at the courthouse too. I did one last week in Edmonton on domestic violence, actually. So I think these are great. It's just it'd be nicer to be in the same room. Take care.
Thank you. Thanks.